And welcome to the Tribal Justice Seminar Project. This is an effort from UC Davis Law School, along with the guiding hand of Chad Smith, who is a former principal chief for Cherokee and who is now the hands-on guide for this project. I have the task of alerting all of you to a huge loss in the tribal justice community over the weekend. Judge Claudette White from Fort Yuma Quechan tribe passed away of COVID this weekend. She was a tremendous force, far outstripping her years with us.
And most of all, I think I'd like to thank all of you for taking time out of your day to learn about using FBI databases to protect vulnerable persons in Indian country. Today, I'll be talking about the Tribal Law and Order Act, exactly what is FBI CJIS, who can access FBI CJIS databases.
Not every case is going to lend itself to a treaty argument, but to the extent that you can do that, I think that, setting it up that way, framing it that way is going to be really helpful.
What's shocking and disappointing is the pushback that I'm getting from state court judges, from state attorneys for the Attorney General's office or assistant DAs who don't understand some of the basic concepts of Native American law. In fact, within the first month, I think half the people who practice in Indian country in Oklahoma started to say, okay, this is evidence by itself why Indian law, Native American law, has to be a part of the bar exam.
My name is Talina No Fire. I am a Cherokee citizen. I was born and raised in a little bitty community called Welling, Oklahoma, very rural, far northeastern Oklahoma. My family is from a place in Adair County called No Fire Holler. And I spent most of my summers running through the woods there with my friends and family, spent a lot of time on the creek there. And I knew that I always wanted to help my tribe.
A concept of how long I have been an ICWA expert. I hope you can see that. That is myself and my grandfather. I went into custody at about 14 months old. I was abandoned by my birth parents at a women's shelter in Tulsa County. Was the youngest of 4 children. In that case, the United States Supreme Court, they did not recognize ICWA as applicable. But what they did not do, which is discussed in some of the dissent, is recognize the child's interest, which is one of my ongoing things. You have to recognize that even, how do I say that? ICWA itself has, 3 interests, and I'm kind of jumping a little bit, so I'll try to refocus. But you have the tribe, you have the parents or the Indian custodian, and you have the child. And what I did not see is the court saying, okay, here's the Indian child interest. That's one of the things that I can tell you. My family walked here on March 23rd. I'm still here. I'm here, right? And I'm here advocating. And I think we hear a lot of the negative about ICWA, but it really is full circle, right? It's full circle, or I wouldn't be here annoying all of you talking too long. So that's the beautiful part of ICWA and why it's so important, because it is protecting what we have a right as people to have, and that is our community and our sovereignty and our own children within us.
Welcome to the 6th in a series of seminars presented by the Aoki Center of UC Davis School of Law. The purpose of the program is to create a network of tribal practitioners, judges, lawyers, workers, clerks, other people concerned with justice in tribal communities.
Judge Thorne, thank you very much. But the hardest question I had asked me was, I was at the Beyond the Bench conference in an elevator with several probation officers from Los Angeles and the presiding juvenile court judge in Los Angeles, to which he asked the question, well, one of the probation officers, mean you're a tribal judge, you're a real judge, you have a real court. The presiding judge, juvenile judge, seemed like he was a little embarrassed to be on the elevator with them and didn't know if I was going to go south on him or go north on him for asking the probation officer asking a question. I said, yes, very much. Same way that this judge here can tell you to go pick up a kid. I can tell you to go pick up a kid, your counterpart. Matter of fact, why don't you come visit me and we'll talk about how we can protect families going forward.
You know, as everybody knows, today we do live in troubled times. But above all of our woes that we face, in my view, the gravest and paramount challenge facing the human race is this worldwide environmental crisis that threatens life as we know it. And sadly, despite our best efforts, this crisis seems to be getting worse and not better over the past 50 years. One of our main problems here in our current Pawnee homeland here is fracking. And fracking, of course, is a rather new, invasive, and environmentally destructive technology. It attempts to wring the last drop of oil and gas out of Mother Earth. And it's produced litigation in 3 forums that are currently pending here. Without a land ethic or a sea ethic, we just, as a society, we just simply can't muster the political will or the economic will, the social will to mount a challenge to this worldwide crisis.
Tribes are going back to healing courts, which is something that had been around in tribes for a long, long time. And you know, these healing courts, they would get diverted. You know, cases or controversies, especially among family members, would get diverted to a tribal elder who's not a non-lawyer. Fascinatingly enough, when you don't have this adversarial proceeding going on, and you have someone that both sides respect as a tribal elder,